Welcome to Transnational Competition Law course, and dear learner and viewer, we have discussed the extraterritorial application of competition remedies in European Union, and we discuss in detail that as to what laws are there which are applied in relation to the competition remedies in Europe, and as well as we also discuss some general law like Organization of Economic Cooperation Competition Remedies 2011 and the United States Antitrust Remedies Manual of 2022. What we precisely discuss is the salient features of the European Commission Notice on Remedies 2004 and European Commission Regulation of 2008 in having a kind of a conception of the competition law remedies which have transgressed its application and replication in other jurisdictions. We have taken note of Article 7 of the European Council Regulation 2003 and we refer to its various features. Now, today we are going to discuss one very important aspect of the extraterritorial application of competition remedies in Israel, as we have seen in the previous lecture regarding the collapse of the behavioral competition remedies in Israel. We have taken note of the fact that how the laws in Israel are going to implement the competition remedies, and what we have deciphered out of the Israeli experiences of competition law and in relation to the competition remedies, we realize this fact that having structural competition remedies, having behavioral competition remedies, and fit it first approach of the competition remedies, how at times the Israeli Competition Authority, while applying the competition law and advancing competition remedies, have tries to see a kind of a very pragmatic and practical approach in giving effect to advancement of competition remedies. And one of its pragmatic approach happens to that it have given a leverage to the structural remedies and behavioral remedies, and it has identified the cases where the behavioral remedies cannot be applied, and maybe that some of the commentators have commented that there has been a collapse of the behavioral remedies in Israel, but that is not true. In some cases, having 0.5 to 2.5% of the merger, the Israeli Competition Authority have not applied the behavioral competition remedies. Before we can discuss the very system of the competition remedies in Israel, it is very apt and pertinent to discuss the economic competition law number 5748, which has been passed in 1998. And this law is the basic law which applies in the Israel uh, in relation to antitrust issues, and it applies that there should not be any kind of a harm to the competition. So the primary objective of the economic competition law in Israel happens to prevent harm to competition and to public. So that is very important because the competition law here takes a very public posture in that sense that it is not going to say a large number of things purview and within the purview and the ambit and the scope of the competition law, while delineating the prime objective of the competition under the economic competition law of 1988. The Israeli government and Israeli legislature wanted to create a kind of a system that this law is primarily aimed to prevent harm to the competition and as well as any harm to the public. Here, it is very soothing to hear that it has addressed the public at large, meaning thereby that Among the public, we have consumer, we have producers, we have market, and we have the general public, which is going to be affected by any kind of a distortion in the market. The Economic Competition Law 1988 of the Israel is also containing very substantive procedures and the rules which applies to various restrictive trade practices, which include restrictive arrangement, the merger, monopolies, and concerted group and solus combinations. So this law as a whole encompasses the rules concerning the structure and the power of the Israeli Competition Authority. And if you look at the very structure of the Israeli Competition Authority, then we realize that there happens to be a Director General of Israeli Competition Authority, and besides that, the Directorate of the Competition Authority, we find a competition tribunal which have a full range of the substantive and as well as the procedural rule to apply the competition law. Then in that reference, dear learner and viewer, it is very important to look at the basic precepts of section 2A of the economic competition law of 1988, which defines a restrictive arrangement as an arrangement between person, including legal entities, conducting business according to which at least one of the parties restrict itself in a manner that might prevent or reduce competition between the person and the other parties to the arrangement or any of them or between the person and a third party. So the ambit and scope of section 2 of the economic competition law of 1988 include all legal entities, all parties, and it tries to prevent and reduce competition between the parties by any kind of the arrangement. Then, in sequence to section 2A of the Economic Competition Law of 1988, here it is necessary to look at section 2B of the law, which also provides conclusive presumptions that an arrangement involving restraint will be deemed to be restrictive arrangement if it relates to any kind of a price to be demanded, offered, or paid, or any kind of a profit to be obtained, or any kind of a market allocation, or any kind of a quantity, quality, types of assets or services in the business. Then in the perspective of section 2B of the economic competition law 1988, it will be deemed to be a restrictive arrangement. So dear learner and viewer, besides a perusal of section 2A and section 2B of the economic competition, dear learner and viewer, a perusal of section 2A and section 2B of the economic competition law 1988 clearly spells out that the Israeli competition law comes very heavily against the restrictive arrangement between the parties and as well as any kind of the restraint which are related to price, profit, market allocations, or any kind of the restraint in relation to the quantity, quality, and types of assets and services are well reflective of the fact that the Israeli competition law happens to be very simple but very far reaching in consequences and the impact. And in that reference, we can see that section 4 of the Economic Competition Law 1988, which tries to establish that the parties to a restrictive arrangement can receive an approval from the tribunal if it finds that arrangement is in public interest. So Section 4 tries to create what has been conferred by Section 2A and 2B, and the same thing gets neutralized under a kind of an exception or a kind of a proviso which has been inserted into the Economic Competition Law Section 4, which give a kind of a leverage and exceptions to any kind of a arrangement which has been pursued in public interest. Then it has to be seen in a different context. Here it is very important that the section 4 uses the word tribunal, meaning thereby that it is something very novel to see and appreciative of the fact that it is very novel to see, and one happens to be very appreciative of the fact that the Economic Competition Law of 1988 of the Israel, besides establishment of the Israeli Competition Authority and establishing a uh, directorate of the competition in the shape of the Director General, who happens to be not only the directorate, but it happens to be the enforcement and as well as the inspectorate to look at the entire competition law issues and enforcement in Israel. Besides that, what Section 4 mentions is the fact that law Section 4 envisages a law which establishes that the parties to a restrictive arrangement can receive an approval from the tribunal, meaning thereby that the entire scheme of the enforcement and advancement of the competition remedies in Israel, it appears that the competition tribunal has also a very pivotal role to play, because whether it is a kind of an arrangement which is in public interest or in a private interest, that is to be decided by the competition tribunal. So the existence of the competition tribunal and the existence of Director General of Israeli Competition Authority are two administrative framework which has been envisioned and envisaged under the Economic Competition Law of 1988. Taken together, what you see that it has a wider repercussions and ramification in advancement of not only the extraterritorial application of competition law, but as well as the advancement of the remedies for competition law. In that respect, we can appreciate further the very purview and the parameters of the Israeli competition law, besides the pale and authority of the Economic Competition Law of 1988. We will refer to the another law which was enacted in 2013, and that law is known as the concentration law. Here, your concentration is drawn to the fact that some of the jurisdictions of the world have used the term concentration instead of the remedy. So it appears that the Israeli competition law, Economic Competition Law of 1988, happens to be of a general nature, but it touches to the issues of enforcement and the advancement of the competition remedies, either by the competition tribunal or by the director general or the Israeli Competition Authority. But the law relating to the competition remedies has been precisely and very concisely addressed in the concentration law of 2013. And the concentration law, the very purpose of the concentration law in 2013 is to reduce economy-wide market concentration and to promote competition in various sectors of Israeli economy. It is just tantamount to what we have discussed under the Indian Constitution and Article 38 and 39 of the Indian Constitution 1950, vis-a-vis the objective of statements and reason of the Competition Act 2002 in India. So the concentration law of 2013 tried to see and to curb all kind of the monopolistic and the oligopolistic tendencies and try to reduce any kind of an economy wide market concentration to promote competition in various sectors of Israeli economy. And the concentration law of 2013 also poses limitation on, among other things, cross holding in a significant non financial entity with a significant non financial entity and control of public corporation through a pyramidal ownership structure. This aspect of the Israeli competition law, in terms of the concentration law of 2013, is a very novel addition to the jurisprudence of the competition law, in a sense that this law moves beyond the monopolistic and oligopolistic tendencies and wide range of market concentration to promote competition in all the walks of Israeli economy and all spheres of Israeli economy. Besides that, what this law tried to target, that it poses limitations, which inter alia includes: number one is the cross holding in a significant non financial entity, and that cross holding in non financial entity is happens to that to be done with a kind of a significant financial entity and the control of public corporation. And then it means that the pyramidal ownership structure means that that the concentration of the power and the market forces should not be vested in few hands. That has been hinted when we talk of the pyramidal ownership structure in the Israeli economy. Dear learner and viewer, what exactly has been denoted by the concentration law of 2013, that it wanted to see that the resources of the country should not be concentrated in the few hands. That's why it keeps a very constant vigil on the pyramidal ownership structure in the Israeli economy. The concentration law, besides keeping a watch and vigilance on the pyramidal ownership structure, also requires consultation with the Director General regarding the advancement of competition in a specific sector. As we have noticed that the existence of competition tribunal and the existence of Director General under the Israeli Competition Authority, then the Director General happens to be a kind of an umbrella organization which try to set the direction, as well as it tries to see the entire inspectorate aspect of the competition law. And it also happens to be a guiding factor in the nodal agencies for all kinds of the enforcement of the competition law. Here, we have to see that besides the concentration law of 2013, the Israel has also passed a law which is known as the Food Law 2014, which primarily deals with vertical relationship between the food supplier and the retailers and regulates commercial relationship between them. So we see that with great sense of confidence and pleasure that the Israeli Economic Competition Act 1988, while dealing with the generic aspect of the competition law and having a very visionary document in that sense, further it has legislated the economic concentration law of 2013, which try to see all kind of the monopolistic and oligopolistic tendencies in the Israeli market. Besides that, one of the very specific dimensions of the food under the competition law happens to be a kind of a great source of maculation, and it can lead to the replication in other jurisdictions. And that's why reading of the food law enacted in 2014 from the competition law enforcement and the competition remedies perspective appears to be very interesting discourse. And as we see that this law primarily deals with the vertical relationship between the food supplier and the retailer, which happens to regulate the commercial relationship between them. And the food law of 2014 also imposes criminal, administrative, and as well as civil liabilities on the corporation. So it is very interesting to see that in matters of the competitive regime in the food law and the market is being administered through the criminal, administrative, and civil liability. A mixture of all kind of the liabilities were imposed to bring all the violators of the food competitive industries to the book. The food law also empowers the Director General to instruct a large retailer that is selling the products of a large supplier in respect of sale slots and to give instructions time to time to a retailer that is selling private label product. So here the role of the Director General as an advisory, as an enforcement, as an inspectorate comes into picture to monitor the entire food industry and the private labeling of the product by all kind of a retailer and the seller. So what we see that under the food law of the Israel, we find so what we generally see that under the food law of the Israel, that large supplier must not inter alia recommend, dictate, or intervene in any manner in physically arranging the products in the store or for a larger retailers, meaning thereby the inventory and stock and should not be done, and there should not be any kind of a hoarding of the food in matters of controlling the monopoly and as well as the pricing in the food competitive market. So the food law uh, happens to be very clear and try to recommend all kinds of dictation and intervention if there happens to be any kind of a hoarding in matters of food which are directed towards having anti-competitive behavior in the food market. In this respect, the Director General of the Israeli competition authorities have announced a block exemption to the law which allowed a large supplier to physically arrange products in accordance with the retailer's planogram has been cancelled in from January 2024. So the action by the Director General of Israeli Competition Authority in blocking exemption to the law happens to be very salutary impact in the sense that it has created a large dent on the large supplier to physically arrange products in accordance with the retailer's planogram was was happened to be cancelled by the Israeli Competition Authority. And such kind of a blockade and such kind of an embargo on any kind of the retailer planogram is something to be seen with great respect and with great hope that the competition law and the anti-competitive behavior should not be the part and parcel of the food law. And the food law 2014, a very specialized kind of the enactment of the Israel, happens to be a guiding force in this respect. So dear learner, what we discussed today is the fact that we try to see that extraterritorial application of competition law from the standpoint of view of the Israel's competition law in matters of Israeli Competition Authority, Israeli Competition Tribunal, and we have noted the Economic Competition Act or Economic Competition Law of 1988, its provisions of Section 2A, 2B, and Section 4. Vis-a-vis, we also discuss the Concentration Law of 2013 and the Food Law of 2014 to have a kind of a clear legislative picture of the Israel's competition law and its linkages with the extraterritorial application of competition law vis-a-vis the enforcement and the competition remedies seems to be a great addition to our knowledge. With this, I thank and I wish you the happy learning to look at the entire conspectus of the Israeli competition law. Thank you very much.